Today's topic is about the things you need to know about arrest. And the first part of this four-part series um, is about sources or the legal basis in which when can a person be arrested under our law, what is the procedure during an arrest. Then we have to tackle first, even before defining what really arrest is under our laws. Okay, these four are the legal basis of arrest: the 1987 Constitution, and this law, as you know, is the fundamental law of the land. Now, if something is violative of the Constitution, then that could even absolve an accused if he was arrested in violation of his constitutional rights. Then his case will have to be dismissed. Now, I included here, let me point out, Republic Act 7483 because it is very material, especially if a person is under custodial investigation. He has to know his rights, and this emanates from the 1987 Constitution. Now, I included this again because there is a fine line between custodial investigation and arrest. Then later, we will find out what's the definition of arrest. We also have the rules of court, specifically the rules of criminal procedure, because our rules of court is composed of many rules of procedures, like civil procedure, special proceedings, all those cases that may be filed before the courts. Now, in the rules of criminal procedure, the police officer, even the judges, are mandated to follow certain set of procedures, rules regarding the issuance of a warrant of arrest, even the issuance of a search warrant. And during the execution or the service, or when a person is informed of his the basis of his arrest, it is found in the rules of criminal procedure. And also jurisprudence. Jurisprudence is the set of cases as decided by the Supreme Court with finality, because that's the supreme, it's the highest court of the land. Now, actually, this is very important to know that how the Supreme Court has defined through time in progression. Even if you recall our featured case, the Stonehill versus Diokno, previously it talks about general warrants. So in jurisprudence, actually, it's the practical side of, or the application of our laws. And given that we know the four legal bases of arrest, we have to know the constitutional provisions that mention arrest. Article 3, Section 2, this is very familiar to law students, the Bill of Rights, and most likely you memorize the same. Now, the Bill of Rights indicates or lists down, it's a listing of the rights of an individual vis-a-vis towards the government or the state. Now, the Bill of Rights, it's not actually the granting of rights. It does not grant rights, but actually it recognizes the existence of these inviolable rights as per like our human rights law. That's the ultimate source, actually. Now, Article 6, which tackles the legislative department, it mentioned also arrest, that our congressmen is immune from arrest during the time they serve in relation to a certain situation. Like there are elements also that must be complied with. Now, Article 7 talks about the executive department. And although Article 7 and 6 is not part of our lesson, I'm just telling you that these provisions, these articles of the 1987 Constitution are very crucial articles, especially the Bill of Rights. And it is where arrest is mentioned. Now, specifically, Article 3, Section 2 of the Bill of Rights, although this is a very long sentence, but I have to quote it in full because it encompasses everything and it cannot be complete without a word of it because it's complete in its whole again. Now, let me read it for those who are listening to this video. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purposes shall be inviolable. And as I said a while ago, the basis actually of the Bill of Rights is the basic human rights, and human rights is inviolable. And no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. Now, this must be followed because the right, again, of the people is inviolable, and it is a violation of your personal freedom and liberty. So, search warrant and warrant of arrest must be issued only if there is probable cause and determined by the judge. So this imposes a personal obligation on the judge, and the complainant must have his witnesses, and there should be a particularity in the description of the place and the persons to be seized. So the person must be identified. A person is identified by his name or his nickname, which is in some information it says AKA or also known as. So in the next lesson, we will tackle again the Republic Act 7483. Now, I want to thank those people who constantly followed and liked our Facebook page and also our YouTube channel, and I think it's almost 1,600 subscribers. Thank you for that, and please don't forget to share those the videos to your friends or anyone you know who could relate, especially the law students in this time of the pandemic. And our work in progress, our website, so we're continuing to develop it and improve it. Thank you so much and have a happy day.